Good morning, Ms. Miller.
Good morning, Your Honor. I- Oops,
We aren't scheduled until 9 o'clock, but I'm sorry, we're scheduled at 9 o'clock. I haven't seen Mr. Johnson as of yet.
I've been trying to reach him and he has not communicated with me since I think the 16th. We were talking and then I didn't hear anything else from him. He moved out of the apartment and I never heard from him after that. I
The
sent him
concern
a,
I have is that I don't see a proof of service in the file.
Your Honor, we had a process server go to him twice and he did not answer the door. So then my son and I went to see him and he acknowledged service on the face of the summons. And I have copies of that I can deliver to the court.
This is 224738 LT Barbara Gail Miller versus Tyrone Johnson. And Ms. Miller, I'm looking at the summons in the court file where it says moving out 11/13/2022.
And his initials are after that, Your Honor.
Ms. Miller, my policy is 15 minutes after the scheduled start time, so if Mr. Johnson is not here by that time, I'll take your default. Also in the file, there is a certificate of mailing from September 9th, 2022. Oh. Which I presume would have been from the demand for possession. Okay. We'll sit tight and see if he appears. If there's something else you need to do for the next 13 minutes, I'm not gonna hold you, but
Thank you, Your Honor. I will wait patiently. Thank you.
Thank you, ma'am. Ms. Miller, I'm looking in the file and my concern right now is that Mr. Johnson is not here. It's 9/11 and there is no proof of service in the file. He's not participated or appeared at the first hearing on October 19th, the second hearing on November 30th. The case was scheduled again on December 7th. He has never appeared, and on the front of the summons, there is an indication moving out 11/13/2022, 7 p.m. with the initials T and J. But that does not acknowledge to the court that he received the summons and notice to appear, the original notice to appear in this case. So I'm inclined to do one of two things. We either adjourn it and you actually get service by either certified mail or, I'm sorry, not certified, it'll be posting or personal service, or dismiss the case if he's already vacated the premises and you retake the premises.
I would, Your Honor, could you state those again?
Because there's no proof of service in the file and his signature on the front of the summons does not acknowledge that he actually received the summons and complaint and the notice to appear in these matters, and he's never appeared or presented himself to the court either way. I'm inclined to either adjourn the matter for you to serve him, but I think that that's complicated by the fact that you said that he's moved from the premises. So that's number one. The alternative is to dismiss the case this morning, and if he's already moved from the premises, he's vacated the premises in their entirety, then you would just retake the premises and wouldn't have to either serve or refile the case.
Your Honor, on the summons, it's got received and his initials are on that 11/4/22 at 5:25 p.m. But you're saying the court does not acknowledge that as service. So
But if he wrote received on the copy that's in the court file. So what did he actually receive?
the whole packet was stapled together, Your Honor. He received everything. And he has contacted me while I was talking to the court, saying that we could enter a settlement.
What I'm suggesting is the copy that's in the court file has his original ink signature on it. So what is it that he received?
The summons.
The summons and the complaint. It was all stapled together.
Okay, who is that's sitting to your left?
My son, Philip Miller,
Okay,
who was present when Tyrone Johnson received the summons and the complaint.
And also.
Okay.
That he'd be moving out on. the-
Phil,
Yes,
what I'm saying is, if Mr. Johnson signed that he received this document, the court would, I would suspect not, that the court would not have the original ink signature. So he signed, are you suggesting that he signed this copy but took another copy?
yes. Yeah, we left him with, we had another packet that we left with him and he signed this one and we walked away with one.
Throw your chair around. Yeah.
Ms. Miller, he's fine. I recognize that sweatshirt anywhere.
Exactly. And
Are you saying something else?
well, just that, he represented to us on that date that he would be out on the 13th, but wasn't out until last week.
So just so we have a clear record. Statement from Ms. Miller is that she, as an officer of the court, is maintaining that Mr. Johnson accepted service of this case on November 4th, 2022 at 5:25 p.m. The court will update its records to reflect that. This case was scheduled at 9 o'clock. It's now 9:16. The defendant has failed to appear. Ms. Miller, how would you like to proceed?
Well, I would like to proceed to enter a judgment, but the court is reluctant to do that and wants to adjourn it or dismiss it. Is that correct, Your Honor?
Well, Ms. Miller, I'm retracting my original statement because your assertion as an officer of the court is that there were two packets presented on that day and that Mr. Johnson signed on one and received the other.
That is correct, Your Honor.
It would have been, I guess, a cleaner record if you then had submitted a certificate of personal service. Even though there's a signed acknowledgement on the front of the summons, it's better if somebody signs the bottom back part that actually says acknowledgement of service, or that the proof of service indicating personal service had been made. So based on your assertions and the comments added by Mr. Miller, the court will enter a default this morning. What's the amount due and owing, ma'am?
Do you want me to recite the parts of the judgment, or the total is $8,175?
No, it's more than that. Hang on.
And plus damages of a broken lock. I'm sorry, Your Honor, that I'm doing this in pieces. A broken lock, the keys broken off in the lock at $150. And then the damage from his smoking in the apartment for 5 months, at which the apartment will have to be washed for another $500, Your Honor.
Ms. Miller, the court can only enter judgment as requested in the complaint, and the complaint speaks to the unpaid rent plus utilities. There was the supplemental for future rent that accrued during the life of the file. So the court would enter a money judgment that had the rents and the utilities as outlined in the lease. I know there's the documents attached to the complaint.
And what about the filing fees and the filing fees, Your Honor?
Automatically your court costs, ma'am. But it would be the rent and utilities referenced in the complaint.
Okay, the rent would be $6,000, Your Honor. And the
And
utilities,
then the utilities,
are another $900.
and then the court costs of $130 filing fee. You indicated you effectuated service. I don't know if you were trying to claim a service fee, so the $130.
Well, we had tried to serve him twice before and have a fee of $100 on that, Your Honor.
$100 for the attempts made by you and Mr. Miller?
No, we had another service, another gentleman trying to
Oh, the
serve.
attempts made by another, okay. So if you would like to submit a judgment in those amounts, the $6,000 for rent, the $900 for utilities, the $130 filing fee, and then the $100 service fee, $71.30.
Your Honor,
The issue with the damages that you listed is that they are not listed in the complaint.
well, how would we have known without being able to get into the apartment? So we should have just listed and potential damages in our complaint.
Well, you don't list potential damages because the non-payment case is just about the non-payment. If people pay, they can stay. So their tenancy will continue. So your request for damages beyond normal wear and tear is usually something that you see after the tenant has vacated and the security deposit has been disposed of, and the itemized list of damages after move out and all of that. it's not anticipated that during the life of a landlord tenant case that the landlord retake and then try to recoup the cost of putting the unit back into service.
I understand, Your Honor. Thank you.
You're welcome. Anything else, Ms. Miller?
Nothing, Your Honor.
If you, I don't know, if you submit the judgment electronically, you can email it over to the civil department, or if you want to bring it over, mail it in. The notes are in the file regarding the amounts that should be listed on the judgment, and we'll sign it and we'll get it back to you and mailed out to Mr. Johnson.
All right, thank you. Thank you very much, Your Honor. What is it? Does the court have a preference of how I do it?
Not at all.
Thank you.
Have a good afternoon.
And the same to you, and happy holidays, Your Honor, to you and your staff.